Thank you. Let me introduce myself. My name is Jimmy Ma. I'm the treasurer of Hong Kong Institute of Arbitrators. On this very interesting topic of conflict laws in international arbitration, our two speakers are Mr. Josiah Folkard. He's barrister from 20 Axis, about 8,000 miles away from us here in Hong Kong. And he's joined by Ms. Elizabeth Chan. She is the senior registered foreign lawyer at Allen & Overy. Josh has a broad practice, arbitration practice, including civil fraud and asset tracing and many other areas. He has acted for clients in the automobile, energy, finance, private equity, IT, M&A, property development, and joint venture and shareholder spheres. Lizzie is very experienced registered foreign lawyer in Hong Kong, where she bases, and her firm is Allen & Overy. She specializes in international commercial arbitration and investment treaty arbitration, and she's ranked as the future leader of Who's Who Legal Arbitration 2022 to 23 and the Legal 500 Arbitration Private Practice Power List UK 2022. Just a few points, in-house matters that I would like to remind everybody before we begin. This webinar is recorded, and the recording will be uploaded to Hong Kong HKIArb's website and the YouTube channel. The raise hand function and the chat function are disabled, and if attendees have any questions, they have to type it in the Q&A box. They will be responded to at the end of the presentation. Attendees are not allowed to unmute themselves, and they are not allowed to start the video. CBD points has been applied for, and we'll send you an email once we receive confirmation from the Law Society of Hong Kong. And attendees, please let us have your evaluation form at the end of it, and so that we will improve in our future organization. Here we are. The screen is yours, Josh and Lizzie.
Well, thank you very much, Dr. Ma, for that extremely kind introduction. And thank you to everyone in the audience for joining us, particularly in the week before Chinese New Year. And a very happy New Year to all of you for Sunday. Looking then at our running order, Lizzie and I will divide this talk on conflict of laws in international arbitration broadly into two sections. First, looking at applicable law, and second, jurisdiction. Now, on applicable law, we will focus on the knotty question of what law governs an arbitration agreement in the absence of any express choice of law governing the arbitration agreement itself. That has been the subject of two recent UK Supreme Court decisions, but we'll also look at the position in other European and Asian jurisdictions. Within the second topic of jurisdiction, we'll be focusing on the question of the standard of review by the court of an arbitral tribunal's decision as to whether or not it has jurisdiction. Now, in England and Wales, this issue is currently subject to review by the Law Commission, who've made what some consider to be a bold and radical proposal for reform. We'll use that proposal as a platform again to take a comparative look across the major Asian jurisdictions. Lizzie will then conclude by looking at drafting tips to avoid problems arising in both those areas of applicable law and jurisdiction. So turning first then to the first section on applicable law, we turn to the vexed question of the applicable law of an arbitration agreement. Now, it may not be intuitive to have to choose the law governing a specific provision of a contract, particularly when you've already chosen the law that should govern the rest of that contract, or indeed from the drafter's perspective, having chosen a law to govern the entire contract. But this issue arises because of the legal fiction that the arbitration agreement is separable from the main contract and has a vitality independent of that main contract. Now, as a matter of policy, this is important because it supports the validity of the parties' choice of arbitration to resolve their disputes. And that's because if the main contract is tainted by fraud or bribery, for example, and void or voidable, the parties may still refer their dispute to a tribunal to resolve it. Choosing the law of the arbitration agreement is therefore very important because without it, your agreement to arbitrate may not be valid. And like this wooden construction, kindly found by Lizzie, your carefully crafted arbitration clause may come tumbling down, rendering your agreement to arbitrate ineffective. Oh my God, Lizzie, it's happening again. Thank you. That's enough of that then. So applicable law issues arise because many jurisdictions, as we've seen, adopt this doctrine of severability. Some adopt it in a stronger form, some in a weaker form, and we'll come on to look at that shortly. That's helpful, but that does lead to different approaches in different jurisdictions as to how to determine the applicable law of that separate agreement to arbitrate. And we'll now go on to look at how that question is answered in first the United Kingdom, and then in France, Singapore, then the Hong Kong SAR, and finally the PRC. So turning first then to the position in the United Kingdom. Now, the applicable law of a contract is usually governed by the Rome I regulation or Rome Convention rules, insofar as not amended by statutory instrument following the end of the Brexit transition implementation period. But arbitration agreements are expressly excluded from Rome I by Article 1(2)(e). So we fall back on the common law to determine the applicable law of an arbitration agreement. Now, these common law principles were settled in the UK by the Supreme Court in Enka, subsequently considered by the Supreme Court decision in Kebabji. And we've got a photo of some falafel there on the slide because the facts of Kebabji concerned what Lords Hamblin and Leggett somewhat tantalizingly described as a distinctive type of restaurant specializing in Lebanese and other Middle Eastern cuisines. Now, this must be an absolutely delicious chain of restaurants to have funded a challenge both to the Supreme Court of the United Kingdom and, as we'll see, the French Cour de Cassation. But I want to start with Kebabji because it's a good example of the problem which arises. In that case, a party called Count Food Group alleged that it was not a party to the arbitration agreement. The majority of arbitrators held that KFG had been or become a party to the arbitration agreement and made an award against it. KFG brought proceedings to annul the award in France on the basis that it was not a party to the arbitration agreement. And the Paris Court of Appeal, which was the level in France that the case had reached before the UK Supreme Court dealt with the matter here, had held that the governing law of the arbitration agreement was French law as the law of the seat, and that under French law, KFG was a party to the arbitration agreement, and so there was no annulment. In England, meanwhile, Kebabji sought to enforce the award against assets here, and the UK Supreme Court held that the governing law of the arbitration agreement was English law, and that under English law, KFG had not become a party to the arbitration agreement. As a result, the award was not enforced here. Now, the Supreme Court in Kebabji confirmed the decision in Enka, and in particular, the principle that under English law, generally the governing law of an arbitration agreement will be the law applicable to the underlying contract, not the law of the seat. And we see that in the two white speech bubbles in the middle of that slide. There are some exceptions to that, said the Supreme Court, in particular where the law governing the underlying contract would lead to invalidity of the arbitration agreement. And in those circumstances, the law of the seat may still have a role. But an interesting point picked up in this green box at the bottom was the effect of the New York Convention, because this is, of course, a principle governed by that convention. And the Supreme Court accepted in principle that the UK section 103(2)(b) should have the same meaning as Article 5(1)(a) of the convention, and that in principle a uniform approach should be adopted across all contracting states. The difficulty, said the court, was that the researchers of council had found no consistency of approach across the different convention states, and therefore the court said it had no option but to fall back on the common law. And those are the principles set out in the middle of that slide. So what was the effect on the enforcement of the award? Well, as I said, the Supreme Court said that the award could not be enforced. And in actual fact, they approved the Court of Appeal's decision to grant reverse summary judgment. So they said there was nothing which could come up at trial that would affect that decision. And this was primarily because of what's been called non-clauses or no oral modification clauses, which were present in Kababji. And we see those articles cited there on the 2 bullet points at the top of the white box. Now, the reason we have a photograph here of Odysseus or Ulysses making his way through the sirens in Homer's Odyssey tied to the mast is that what these non-clauses do is they bind parties to say that they cannot vary their contracts other than in writing. So they tie their hands to not being able subsequently orally to modify their agreement. And essentially it was that principle which the Supreme Court decided meant that it was fanciful that if this went to trial, any allegation about implied or oral discussions about whether KFG became a party could not affect the result. So we turn then by comparison to look at how this case proceeded in France. Now, as I've said, what the Paris Court of Appeal decided before Kababji had arrived in the UK Supreme Court was that the governing law was the law of the seat. Lizzie, could we just go on to the next slide? Thanks very much. And this is the subsequent decision after the UK Supreme Court Kababji ruling from the French Cour de Cassation, the highest civil court in France. Now, in one of the longest single sentences ever seen, highlighted there, paragraph 8 on the slide, the highest court in France confirmed the law of the seat approach. And applying French law on that point, they held that KFG was a party to the arbitration agreement. Now, standing back, that meant that we had the same award being dealt with by Supreme Courts of 2 European states in diametrically opposing ways. The French court saying that the award could not be annulled because KFG was a party. The UK Supreme Court, however, saying that the award could not be enforced because it was fanciful to say anything other than that KFG was not a party to the agreement. And by contrast, in one of the shortest sentences ever, Louis Flannery KC gave his verdict on this cigar, again cited in the bottom right-hand corner of the slide. And it's very difficult, I think, to disagree with that conclusion. Looking then at Singapore by comparison, I'd like to focus on the Court of Appeal decision in BNA and BNB. And I think this is a good example of some of the theoretical distinctions which can arise here. Now, BNA came to what in many cases will lead to essentially the same outcome as kebabji. We can see in the bullet points on the left-hand side of the slide there that what the Singapore Court of Appeal concluded was that an express choice of governing law in the main or underlying contract will often amount to an implied choice of law governing the arbitration agreement. So, as I said, often the same result will be reached as in England. But it's important to note on the Court of Appeal's analysis that the link between the governing law of the underlying contract and the governing law of the arbitration agreement is just an implication. There is no necessary legal connection, and therefore, said the court, this is the second bullet point on the right-hand side, all it is a strong indicator unless there are other indications to the contrary. So that's an example of a slightly different theoretical approach. And I will hand over to Lizzie now, who deal with the position for applicable law of the arbitration agreement under the Hong Kong SAR and the PRC.
Thank you so much, Josh. And let me take this opportunity as well to thank Jimmy for moderating our session and the HKIArb for the opportunity to present, and Lara as well from 20 Essex, and also to wish everybody a very happy Chinese New Year. I'm happy to talk about the position in Hong Kong, and that is usually when the courts are trying to decide what is the governing law of the arbitration agreement, they will deal with the issue as a matter of construction and not necessarily as a matter of applying particular assumptions. I should say, though, that not all of the decisions that Josh has talked about today have been considered by the Hong Kong courts and not by the Hong Kong Court of Final Appeal. So what the position in Hong Kong is perhaps not clear. But generally, we would advise our corporate colleagues that in Hong Kong, the courts treat it as a question of construction. The issue of how to choose the governing law of the arbitration agreement has been determined, however, by the Hong Kong Court of First Instance and the Court of Appeal. Now, I'll take you through a couple of the key cases that have been decided by the Hong Kong courts. But in general, we can say that the courts will respect the parties' express choice of the governing law. If not, they will try to ascertain an implied choice. And if they can't do either of those, they might look at the law that has the most real and closest connection to the agreement to arbitrate. And in that regard, they will consider a range of different factors, including the law governing the underlying contract, the chosen seat of the arbitration, etc. But I'll take you through a couple of cases in Hong Kong, which shows you the approach that the courts have taken. So the first case is the Klockner decision in the Court of Appeal. And there the Court of Appeal said, if there's an express choice of law to govern the contract as a whole, the arbitration agreement will also normally be governed by that law. So that is quite similar to the anchor position that Josh has just described. And the court there said that this is whether or not the seat of the arbitration is stipulated and irrespective of the place of the seat. And in that case, the court was quite emphatic as well that there is no rule that the lex arbitri must be the law of the seat of the arbitration. So I suppose in some ways we can also see maybe the making of a presumption there. The next case is the C Powerful case in 2016. And so there again, we see like the anchor position again, where because the clause, the governing law of the main contract contract specified the application of English law, English is the putative applicable law of the arbitration agreement. The next case is the OCBC decision in 2020. And here the court said that it was only if agreement could not be found that the implication rose from the choice of the seat that the law of the place would be the lex arbitrary. So again, you know, we see hints of the French decision coming through here, where there might be a presumption that the choice of the seat is the chosen law of the arbitration agreement. That said, though, in the present case, the court held that the governing law stipulated in the purported arbitration agreement under the Charter Party was English law, notwithstanding that the seat of arbitration was Hong Kong. The next case is X and Z PRC, also in 2020. And I think this one and the next one may have been decisions by the same judge. It's got quite a similar approach. So first of all, you ascertain the express choice, if there is any, and then the implied choice and the presumed common intention of the parties. And now here, because there was no express or implied choice, the court looked at, you know, construe the contract. What would be the governing law of the underlying of the arbitration agreement? And she had a look at the governing law of the underlying contract and the law with the closest and most real connection with the agreement to arbitrate. And this would include a range of factors, including the chosen seat of the arbitration. This is quite similar to the situation, to the approach taken A and D, where the court held that there is no express agreement between the parties as to the governing law of the arbitration agreement, and the determination of that law is a question of construction and matter of interpretation of the relevant clauses of the underlying contract and of the arbitration agreement itself, read in light of the surrounding circumstances and commercial sense. So I guess to conclude from Hong Kong, it may differ a bit from the other jurisdictions in that there's no one presumption that tells you what the governing law of the arbitration agreement will be, but the court will construe the contract as a whole and look at any choice made by the parties, any implied choice, or relevant factors that would indicate the law that's most real and closest to the arbitration agreement. As Josh mentioned at the beginning of the presentation, we're also going to look at the PRC, which again takes quite a different approach to the other jurisdictions. Now, first of all, we need to start by being clear that the current PRC arbitration law doesn't actually have a concept of the seat or place of arbitration. But somewhat confusingly, it doesn't mean that the seat or place of arbitration is never mentioned in any PRC legislation or interpretations by the Supreme People's Court. And in fact, there are a number of different laws and SPC interpretations that actually do mention the concept of the seat of arbitration. That said, there are draft amendments to the PRC arbitration law that would put a premium on the parties' agreement on the place of arbitration, or if they don't agree, or if it's not clear, the place of arbitration shall be the place of the arbitral institution administering the case. This itself can be a potentially ambiguous concept as well, because, for example, you might have arbitral institutions that administer a case and then have branches in different cities or in different jurisdictions around the world. So that you still might have ambiguity as to which jurisdiction should be the governing law of the arbitration agreement. But what is the current approach by the PRC courts? Well, first of all, you would ask whether the parties have agreed on the law governing the arbitration clause, and if they have, that express choice would control. And then the default rules is that the law of the seat or the law at the place of the institution applies. And if there is a conflict, the validity principle applies. That is, pro arbitration. So you would apply the law that would find the arbitration agreement to be valid. And if you don't have that, then you might apply the law of the forum, which could be PRC law. And the one thing I found interesting when I was doing my research is that generally the law governing the main contract is not actually relevant to an inquiry about whether the parties have to the parties' choice or lack thereof over the governing law of the arbitration agreement, which takes us quite far, I think, from the anchor position that Josh was telling us about. And then I think I'm passing it back to you, Josh, for the second part of our presentation.
Thanks very much, Lizzie. That's really interesting. We're now, as Lizzie said, going on to look at the second half, which is jurisdiction. And as I said in the introduction, we are focusing here on the correct standard of review once an arbitral tribunal issues a partial award, deciding whether or not it has jurisdiction. Now, broadly, although I think we'll see in relation to the PRC not exclusively, there are broadly two options here. The first is a de novo decision, which takes place on a full rehearing basis. So this is where the court decides afresh whether or not the tribunal had jurisdiction, uninfluenced by the arbitral tribunal's decision in its partial award. The second option is a form of appellate review, similar to an appeal from a first instance court. And this approach really takes into consideration concerns that new factual material on the question of jurisdiction ought not to be allowed at that late stage. Now, the current position under English law, in particular, Section 67 of the Arbitration Act 1996, for challenges to awards on the basis of a lack of substantive jurisdiction, is the first of those approaches, a de novo review. And the standard of review is one of the issues currently being considered by the Law Commission in its broader review of the 1996 Act. Now, the stage which this has now reached is a consultation paper, which was released by the Law Commission in September 2020, along with a summary document. And that is open for consultation with stakeholders, and many law firms and chambers in London have been putting their tuppence in the ring for that. Now, as far as we're concerned, the key point here is that the Law Commission proposed that the standard of review under Section 67 be moved to the second basis, which I mentioned, a form of appellate review. And I've set out the Law Commission's provisional reasons there on that slide. We see in the first box, this is from the summary document, the overall proposal, which has been opened up to consultation. And then effectively in the second box, the reasons which are advanced in the consultation paper. And this is quite interesting, actually, because the Law Commission has taken issue with some of the original arguments made in the DAC report, which accompanied the original draft bill for the Arbitration Act. So there's a bit of a sea change there in how the framers see this legislation. Now, I think the first and lead reason, perhaps, is this first one, cited at paragraph 8.42, which is avoiding this heads I win, tails it does not count approach. But also we see in the bullet points after that, there's in particular a worry about parties bringing in vast amounts of new factual evidence on a de novo review. Now, essentially, I see this as a tussle between what I might say on the one hand are the theoretical purists, and on the other, the pragmatists. The purists, and I'm afraid I have to declare my interest here as something of a theory ultra, say, well, if a tribunal does not in fact have jurisdiction, even by a slim margin, it cannot pull itself up by its own bootstraps. So if we take the position, for example, where the question of whether the arbitral tribunal has jurisdiction is a close call, you cannot have a position where the tribunal just about decides it has jurisdiction, although on a de novo review that would be found to be wrong. But there was not such a bad error in the tribunal's reasoning that would not then be overturned on appellate review. Because in those cases, you would potentially have an arbitral tribunal going on to make a final award in circumstances where it did not, in fact, have jurisdiction. So that's the concern of sort of the purists. The pragmatists, if I can put it that way, will say, on the other hand, well, why should a party who's lost on jurisdiction before their chosen tribunal then be given a second bite of the cherry, perhaps to adduce factual evidence, which it always ought to have adduced in the first instance, or is just being vexatious, oppressive, or seeking to increase costs and time of the other party by having another go. So that's really where the land lies in the UK. If we look then at the comparative situation, I'll hand over to Lizzie shortly again to deal with the Hong Kong SAR and the PRC. But I must say that Singapore's approach appears to me to have much to recommend it. In principle, this is a de novo review, and we see that in particular from the cases of PT First Media, TBK, and Sanlam Investments, sometimes known by the opposing party's name, Government of Lao People's Democratic Republic. But as highlighted by the Law Commission in its consultation paper, paragraph 8.28, looking at the comparative Singapore perspective, new evidence is admitted only in limited circumstances, akin to when new evidence might be admitted on appeal. So if we like that, it takes the theoretical de novo approach, but strips out some of the concern about parties being able to adduce new documentation and evidence at a late stage. I'll hand over now to Lizzie, who will look at the position, as I said, in Hong Kong and the PRC.
Thanks, Josh. So turning to Hong Kong, it's quite similar to Singapore. So under Section 34 of the Arbitration Ordinance, if the tribunal has determined as a preliminary question that it has jurisdiction to hear a claim, the objecting party has 30 days after the jurisdiction ruling to appeal the decision to the Hong Kong Court of First Instance. Now, no further appeal lies from the Court of First Instance, and the arbitration can continue while the appeal is in progress. Taking a look at the C and D decision in the Hong Kong courts, the standard of review is to the standard of correctness, and a de novo approach will be made as well. So that's the situation in Hong Kong. Probably the most different of these jurisdictions is the PRC, as Josh mentioned. So one of the interesting things in the PRC is that it doesn't fully recognize the principle of competence, which is really the mirror principle to the principle of separability that Josh mentioned at the very beginning, and when we displayed the GIF with the wooden construction falling down. So the whole point of having this legal fiction of a separable arbitration agreement is so that we can respect the parties' decision to refer their dispute to international arbitration. And that's why we have the concept of competence, because it gives the arbitral tribunal the first go at determining the dispute between the parties in the forum that the parties had chosen. And then only thereafter should it be reviewed by court. So currently competence is not fully recognized under PRC law. So it means that an arbitral tribunal does not have the ability to determine its own jurisdiction if a party challenges the validity of the arbitration agreement. Instead, parties in arbitrations governed by PRC law can only challenge the validity of the arbitration agreement to the administering arbitration commission or the competent Chinese court. However, there are amendments to the PRC law, which is what I mentioned earlier as well, that would empower the arbitral tribunal to determine its jurisdiction, and only after it has done that would a Chinese court review that decision. That said, I'm not sure when these amendments to the draft PRC law will be, and for the time being, it will be the status quo that I've just described. Now, we turn to the final substantive section of our presentation, which really tries to bring together all of these different issues. I mean, assuming that you have made a choice of the arbitration agreement, then you would avoid a lot of the pitfalls that we have been discussing about which jurisdiction should you pick to be the law of governing the arbitration agreement. So just to cover the different laws that you would select in your arbitration agreement, I think it's pretty clear that you should pick the governing law of the contract. And so in a contract, you should make it clear that this law applies to the contract as well as any non-contractual claims, to the extent that you also include non-contractual claims in the scope of your arbitration agreement. Now, I have a lot of sympathy for the presumption that when you choose the governing law of the contract, you also choose that law to govern the arbitration agreement. I think that the separability of the arbitration agreement principle is one that works really well to support parties' choice of choosing arbitration as the forum for resolving their disputes. But I think a lot of people, including legal counsel, like this idea that this one clause in a contract is separate from the rest is not an intuitive point. But I think it is, in general, really important to also specify the law governing the arbitration agreement for all of the reasons that we have just covered in today's presentation. A question that we actually often get asked in the course of our work, including from our transactional colleagues, is why, if you've chosen the same law for both the governing law of the contract and the law of the arbitration agreement, why would you say that twice? And it is for all the reasons that we discussed today, and that is, if you don't choose your arbitration agreement, the law of the arbitration agreement, then you could have a situation where there's a dispute about it, and your arbitration agreement may be found invalid on the basis of a law that you hadn't even thought about applying to your contract. So it's important to specify the law governing the arbitration agreement, because this governs the existence, scope, validity, interpretation, and effects of the arbitration clause. And typically, we would recommend to our clients that they should choose a law of a pro-arbitration jurisdiction, or one that matches the law of the seat and or of the contract. As much as possible, it's often simpler to have the same law govern the contract and the arbitration agreement, and that be the same as the law of the seat. Although, of course, in many of our transactions, it is quite common to have split laws. So sometimes you have a law of the contract that is different to the law governing the arbitration agreement. That does arise sometimes, but also in some Asian jurisdictions, a split governing law or split governing law clauses will not be accepted. So it's quite important to stipulate that. In some cases, we might not suggest, in some quite rare cases, we might not suggest including a law governing the arbitration agreement, and then advising that the fallback should apply, which is the case law that we've talked about. So in this regard, it becomes very important actually to think about, where the seat is, where the arbitral award is going to be enforced, and what law governing the arbitration would be the appropriate one. And then, of course, it's also important to choose the seat, because this will also determine the lex arbitri. The law of the seat will provide you with the default procedural rules, which will supplement any chosen arbitration rules, if there are any. And the law of the seat will govern challenges to jurisdiction as well as to awards. And it's generally recommended to choose a reputable seat, and one of which, of course, is Hong Kong. And then last but not least, it's very important to be clear about the scope of your dispute. So be clear about the scope of the claims that you submit to the tribunal, for example, whether it's contractual obligations only or also non-contractual obligations. Are there going to be any carve-outs? And you have to make those very clear. If there are carve-outs for certain types of, say, technical disputes, or say the determination of put call options, then you might have special procedures. And in some instances, you also might want to expand this, the jurisdiction of the tribunal, for example, to determine unfair prejudice claims as well. So that's possible, but you need to be specific about including extending the tribunal's jurisdiction to matters of the company's affairs. And then the last point on the slide is about procedure and standard of review. So this goes to Josh's point about what the seat may determine in terms of an appeal or rehearing of jurisdictional challenges. So one thing to think about when you're drafting a contract is whether you need to have bespoke rules that contract out of any requirements or procedures that would apply under the law of the seat. And yeah, you would need to consider also whether they are mandatory provisions that the parties can't contract out of. So I see this brings us to the last 15 minutes of our presentation. So the substantive part of our presentation over, and we would now very much welcome any questions you have.
Thanks very much, Lizzie. So we've had a question in during the course of the presentation. Thank you very much for that. We'll come to that in a second. Please do feel free to put any further questions in the chat and we will adopt those. Lizzie, could I just kick off by asking you, in relation to the last part of your previous slide about advising clients in relation to rules at the seat, obviously you're quite familiar in England with clients being advised as to the possibility of the appeal on a point of law, section 69. That's also something that's being considered by the Law Commission. On section 67, which I was talking about, challenges to jurisdiction, do you see greater scope there to advise clients on that issue if the Law Commission proposal is recommended, or is this not really an issue in the transactional sphere which comes up?
I think if the Law Commission did change its approach and make it an appeal standard, it is something that we would certainly highlight to our transactional colleagues. They are normally the ones who are advising the clients on the drafting of the contract. And I suppose we would need to think about it from the client's perspective. You know, are they going to be a party that is likely to want to challenge the jurisdiction of the tribunal, or do they think that their counterparty may want to challenge the jurisdiction of the tribunal? Like usually you would think that the parties who choose arbitration actually want the arbitration to be valid and to determine the party dispute, but occasionally that's not the case. So I think we would flag that issue to our client. One thing I would bear in mind is we generally try to keep our arbitration clauses as simple as possible. So while in our standard form precedent, we will flag these issues, possibly in a footnote, we may not necessarily include it. in our advice, we'd certainly highlight it to our colleagues, and then for them to decide if it's worth raising it with the client. But quite often, I think for some clients, that these issues tend to be like quite theoretical. So there's a question as to whether you would want to include it in your arbitration clause, particularly if there are other elements of the arbitration clause which may be a little bit controversial already.
That's very helpful. No, thanks very much. Really good to see the practical side of things at that stage. Look at some of the other questions. So Zil Shah, thank you very much for the question about kebabji and the practical implications. I'll take that now. It's a very interesting question. Essentially, the practical upshot of the differing decisions in kebabji was a race to enforce against assets in the different jurisdictions. And essentially, it will come down to, are there assets of KFG in France where the award has not been annulled, which the arbitral award can be enforced against? Following the UK Supreme Court decision, KFG should be fine with assets in England. You raise, however, what's the position in relation to other jurisdictions? That's a very good point. In a sense, that will depend on those jurisdictions' private international law rules as to the applicable law of the arbitration agreement. If they follow the sort of French approach, one would expect they come to similar conclusions as the Cour de Cassation. But I think there is an interesting point here that Article 5.1a of the New York Convention, as I touched on in the presentation, foresees that there'll be a uniform approach to this question. And I think the point which was made amongst other people by Louis Flannery KC, as we saw on the slide, is that it's somewhat regrettable that although there's supposed to be this uniform approach, we do now have this sort of bifurcation in different jurisdictions into positions sort of broadly in tune with the English position or in line with the French position. And it is possible that in relation to other jurisdictions where there are assets, we see further differentiation of approach. But I think the headline point is they'll need to go and see some lawyers in Switzerland and New York and find out what their rules equivalent to ENCA and kebabji are. Lizzie, there's been a couple of questions more on your slides. Would you like to deal with some of those?
Sure. So let me deal first with Suresh's question, which is, what are the jurisdictions that don't permit split choices of law, and how would the tribunal or court deal with that situation? So off the top of my head, I don't actually recall which are the jurisdictions that don't permit split choices of law. But as to how the tribunal court deal with the situation, I suppose would be determined by what is the applicable law. So I suppose in a jurisdiction that doesn't permit a split choice of law, perhaps the arbitration agreement would not be, maybe the arbitration agreement would not be valid, but then you would have to understand under that jurisdiction's law, what is the consequence? So for example, is a consequence that the arbitration agreement is just invalid, and then you have to go to the courts, for example? Or is it that if you have a split choice of law, one of those choices prevails, or might there be a default choice by the law of the jurisdiction? I think as to the second part of this question, how the tribunal court would deal with it would depend on what the conflict of law rules are in the relevant jurisdiction, and what are the consequences of not permitting the split choice of law. And then I'm happy to take also Mei Yin Chung's question, which is, if both parties of a contract are in Shanghai, would the Shanghai Arbitration Center be more appropriate, or would Hong Kong be more appropriate? This is actually a much broader question about I assume this is about both a question about the choice of the arbitral institution. So there's the Shanghai Arbitration Center, and then whether where you would also seat your arbitration. I think, first of all, as far as the choice of arbitral institution goes, many of them are very reputable and very good. One question I have is, what is meant by Shanghai Arbitration Center? Are you have to refer to, I'm not aware of the Shanghai Arbitration Center, or there might be like a Shanghai International Arbitration Center. I think you have to be careful about getting the name right. And then in terms of seat, for example, if you were choosing between Shanghai and Hong Kong, typically Hong Kong is regarded as a very reputable seat. I think, the Queen Mary survey ranked Hong Kong as one of the top 3 jurisdictions for arbitration. So Hong Kong could be good. And then as to your question about whether both of the parties of a contract are in Shanghai, a question to my mind arises as well as whether you could even have international arbitration seated in the PRC, because my understanding is that you have to have a foreign element in the transaction. So that's so I think that the essential answer to the question is you would need to pick an appropriate arbitration center that has all of the rules and things that you want for a transaction. You would want to pick an appropriate seat. For example, before I mentioned the importance of a robust arbitration law and an independent courts that provide an appropriate level of supervision and intervention in the arbitration. And then you would also need to consider whether you could seat, like whether your arbitration agreement would be valid in wherever you decided to seat the arbitration. And Josh, do you want to take the last one? Oh, I think there's a couple. Oh, there's quite a few more actually. Yeah.
Well, yeah, we've got some comments on yours, Lizzie. So just looking at Howard Coleman's, Howard, nice to speak again online. So your question is, yes, about this sort of unusual position where you have a defective agreement by reference to a non-existent basis. So I think there's 2 questions there, really. One is it possible to determine sort of a seat where you have that kind of pathological choice? Section 3 of the English Arbitration Act deals with that. And essentially questions which arise there are like in the Naviera case about whether a reference to a geographical place is just a physical place of the arbitration or a place of the seat. If you can read a place of the seat there, then in such a clause, you would have a seat which would then deal with, for example, the appellate procedures, jurisdictional challenges, which we're talking about, like section 67. On the other hand, there's sort of drawing out of that clause, I think, an interpretation or construction as to what it might mean, and questions, as you said, of sort of formal validity. That interpretation question is a question for, under Enker and Kababji, the law of the underlying contract in general. But as I said, there is an exception to that where the choice of that law would lead to invalidity. And that's possibly raised by your point about non-existent basis. But in principle, I think that issue of construction will go to the law of the underlying contract, and then any questions about sort of procedural control to the law of the seat. Just one other point which I wanted to pick up on in relation to the Law Commission's proposed amendments on jurisdiction, which sort of links to this question, is if section 67 is amended, how does that fit with the jigsaw of other parts of enforcement of arbitral awards and questions of jurisdiction? And there's 2 other potential bases I think we need to think about. Section 32 of the English Arbitration Act, which is where the parties go to the court without a partial award from an arbitral tribunal about its jurisdiction, to just ask the court whether the tribunal has jurisdiction. So the first time jurisdiction is considered is by the court by virtue of the party's choice. The second, although this is used very rarely now, is that it is possible to enforce, obviously, an arbitration award at common law. That's not popular because it means bringing a claim on the award, and it's a much lengthier process than the sort of expedited procedures under the New York Convention. But it's important, I think, to bear in mind that if one were to bring a common law action on an arbitration award, it's a defense to enforcement that the arbitral tribunal did not have jurisdiction. But at common law, that would be determined simply on the balance of probabilities. So I think if the Law Commission is going to propose tinkering with the standard of review under Section 67, there'll need to be careful consideration given not just to Section 32, which is covered in the Law Commission consultation paper, but also possibly what you do about this alternative route under the common law, because although little used, one could then have an out-of-step position with different standards of review for different methods of enforcement. I see we've got a couple of minutes left. Lizzie, do we have any other questions or any other final comments you wanted to make?
Did we answer Nishat's question already? If the governing law of the arbitration agreement is not specified?
Yes.
Okay.
No, thank you very much. So yes, so I think under the English and the Singapore position, generally it would be the law of the main contract, and that sort of NKKBabji, and as we saw the BNA case, but doing that by implication. It's the French position which would, sort of in the absence of that express choice, adopt the law of the seat. And obviously that's followed in some jurisdictions which would apply the French-based position.
And the Hong Kong one, as I mentioned, is the courts generally approach the question of which is the governing law as a question of construction. And you would look at the express choice by the parties, implied choice, potentially the real and most closest, the law that has the real and most closest connection to the arbitration agreement in Hong Kong. And then in the PRC, typically the law of the main contract is not relevant, but the law of the seat may be in the absence of parties' choice. And I just wanted to flag as well, Susan has very helpfully identified some Shanghai arbitration commissions. So there's the Shanghai Arbitration Commission and also the Shanghai International Economic and Trade Arbitration Commission. So all is to say, all these arbitral institutions have very similar names. And you know, if a court is kind to you, they may uphold an incorrectly named arbitral institution as the one you actually had in mind, but as much as possible, get the name right so there's no ambiguity. I think that's all the questions we had. We're right on 7 o'clock.
Yes, thank you so much to Josh and to Lizzie. We are very fortunate to have two very experienced international practitioners in arbitration, covering a very interesting topic on the applicable law to arbitration agreements, which I think after having heard the comment made by Frederick KC, whether it's 8 or not, will be open to our individual comments. So thank you for the participants as well,